Hello, I'm John Grom, and welcome to the 57th Right and Left Discussion Forum. The purpose of our discussion forum is to demonstrate that civility is not only possible in discussing contentious topics, but necessary if common ground is to be found. Today's topic is the question, should the Supreme Court consider public opinion and politics in deciding cases, or should they just go strictly by the Constitution? Today's panel, beginning on my left, is Patty Haskins, retired math teacher and current member of the Wadsworth City Council. On her left is Bryan Laubaugh, president of R&B Financial Services, and on his left is Jerry Ritzman, chairman of the board of Ritzman Natural Health Pharmacies. Patty.
Yes.
I always stumble over Richmond for some reason. I don't know. Some people believe that the only guideline for deciding Supreme Court cases should be the Constitution. Others believe that the Constitution is an outdated resource for dealing with modern issues, and that current public opinion is a more suitable guidepost for dealing with contemporary problems. What do you think?
I think we first have to look at the Supreme Court's duties, which basically their duty in a nutshell is to interpret the constitutionality of laws and regulations that are presented before them. They also are to interpret the particular laws that are brought before them and make sure that they are being interpreted correctly. And it is based upon the Constitution. You know, the interesting thing, though, is if you go back into history, even at the time the Constitution was written, there were disagreements about how the Constitution should be examined and interpreted. You know, there were strict constructionists and those that were not strict constructionists. There were those that said if it doesn't say it exactly in the Constitution, then we can't do it. There are others that felt that we needed to look at it as a non-static document, a living document that would grow and change. Mm-hmm. And I think that's the interpretation that most people have taken at this point. I mean, if we haven't, there wouldn't be 27 amendments to the Constitution as it presently stands. As far as your political bias and social mores, I think it's, when we say political bias, I think that whether you're Democrat or Republican, how you interpret that Constitution is going to go back to whether you think that the Constitution should not change or that it can be changed and interpreted in different ways. And that's why it becomes political, because the different parties and sects and different divisions within those parties have different opinions upon that. And as far as social mores, so many of the amendments have come about because of a change in the way society looks upon different issues, whether it be the right of African Americans to vote, to be considered citizens, whether it be the right of females to vote, whether it be the right not to have a poll tax placed on you. So many of these are based upon social ideas that have changed and evolved over the generation. I think one of the interesting ones to look at is the original Plessy versus Ferguson in 1896, I believe, and which stated that that African Americans and whites, they would be separate but equal. And that was the decision at that time, because basically the Constitution originally did not give any rights to African Americans. However, in Brown versus Board of Education in 1954, ideas and thoughts had changed, and the Supreme Court ruled that separate but equal was not constitutional.
Because it was not equal.
Because it was not equal. And the interesting thing was both cases cited the 14th Amendment and the Equal Protection Clause. So you took the same clause and interpreted it in two different ways, but basically because of a change in social values that we had within this country. You look at the makeup of the court itself. There are 5 court justices that were appointed by Republican presidents and 4 that were appointed by Democratic presidents. So you would think, well, the court is always going to vote one way. But that's not the case.
Yeah.
And it's not the case because, although I think a few of the judges are very steeped in their political thoughts and will actually change their opinion on rulings based upon what their party says, there are those on the court that it's very obvious are trying to look strictly at the Constitution and the way the laws should be interpreted. I mean, I have to give credit to Chief Justice Roberts because I think he's one that makes those changes. Kennedy is another one. Kennedy is kind of the swing vote on the courts right now, and he was appointed by Reagan. And so you would think that he would be the conservative on the court, but he tends to go vote both ways dependent upon how he feels about an issue.
So did Sandra Day O'Connor, who was also appointed by Reagan.
Yes, I believe so. And I mean, you look at other situations. We had the recent decision about gay marriage, and I can't remember the exact name of the case. It was like Oberfeld versus.
Yes, you got it right on the nose.
Versus someone.
Yes, Oberfeld versus Hodges.
Hodges. Okay, thank you. And when you look at the reasonings behind that, it was stated that that these people were granted or should be granted liberty, and they talked about freedom of speech and liberty and so forth and so on. Scalia was obviously very opposed to that and said, we're running down a slippery slope, and it was an interesting.
Well, it was a states' rights issue.
And it was a states' rights issue. However, if you look at the Citizens United decision, and you look at his reasoning for his decision in that case, it really contradicts what he says in that one. I mean, there he talked about freedom of speech and that corporations can have this right and they don't have their liberty. But then when it came to the rights of gays to get married, he took a different opinion. And I think perhaps he was a bit influenced by his social values, but it's difficult not to be.
It's worthy of note that 40 years before, the very, very same court that approved Roe v. Wade also decided that the definition of marriage was not a federal question. And they voted 9-0 to not even hear the case because it was a states' rights issue.
Right.
And then they reversed that 40 years later, I think, and during that 40 years' time, tremendous change in public opinion.
Exactly. Well, that's, like I said, with the Plessy versus Ferguson.
Sure, because
Glenn Brown versus Board of Education, you can have a complete change.
Yeah. Well, I think that's because the country was moving in the direction of the abolitionists' thoughts back then.
Exactly.
Yes, Brian, I think that Patty probably gave you an awful lot of things to think about.
Yeah, she did. I really don't believe that the court should be the Supreme Court of public opinion. There are processes in place. It's a democratic process that's in place, and all the amendments that we've had have always come through the legislature. The Supreme Court doesn't decide what amendments get put in, how the Constitution is changed. Their job, as Justice Roberts has said in the past, is to call balls and strikes. And when we allow a court to manufacture out of thin air a definition or change a definition or read in and interpret in the widest possible sense what their feeling is at a particular point in time, only creates issues. And I would cite Roe v. Wade as one of those issues. When the court short-circuited the process, just like they did recently with the Oberfeld and Hodges case, it has only created additional heartache and worry and lawsuits galore for 40 years. It has not solved the problem for Roe v. Wade. And I would contend that this recent Supreme Court their opinion on same-sex marriage is going to create the same issues for a long period of time, because there are certain things that were left out, and all you have to do is read the 4 dissenting justices, and Justice Roberts read his dissenting opinion, which is very seldom done, and he had some pretty strong language. And at the very end he said, you know, for those of you, you know, that are happy about this, that's great, but none of this, and I'm paraphrasing, I'm not quoting exactly, but he did say it's not found in the Constitution. So when you allow this, and there's so much precedent, and that's why we have 3 separate branches of government. We have the legislative process, they make the rules, and that's open to our opinions, and that's where social opinion changes as far as I'm concerned. We can lobby our representatives to change their opinions. It happens in amendments. You can amend the Constitution. I'm all for that. I think there's a proper process in place to do that. It's a democratic process. And sometimes that's a very painful, drawn out.
It's supposed to be.
And that's what it's supposed to be. Judge Roberts also pointed out that just as the wind was changing and getting behind the backs, and this is just, once again, I'm paraphrasing, you can go to the Supreme Court, you know, and read what he said. Just as things were beginning to change and just as the wind was blowing in their back, they pretty much shot themselves in the foot. And so I agree that the Constitution through the amendment process can be changed and can recognize social change and all that kind of stuff, but it's not the court's decision to make that change arbitrarily for everybody else. And if you go with what Scalia had to say, he's like, now we have, by the slimmest of margins, people that can actual rulers. Who is a ruler now? You know,
Yeah, his was pretty caustic.
Yeah, he
Yes.
was pretty caustic. You know, Judge Thomas, he was a little more reserved, but he made the point that why he fell on this particular side of the issue. But I think in a broader sense, and I don't think we need to debate, you know, the recent rulings, but in a broader sense, there is a process in place. The court has short-circuited that process and has repeatedly, and in more instances, short-circuited the process. And I don't think that really helps us, because we're a country of law, and we believe in the rule of law. We believe that the executive branch is responsible to make sure that those laws are put in place and that they're enforced and that they support the Constitution. I don't believe I'm a strict constructionalist where, you know, you just got to go by the readings. But I will say this: when those documents were put together and all the experiences the framers of the Constitution had, those words in there meant something. And there were words that were left out. What's disturbing to me in this latest ruling is on a religious freedom aspect. Now, here you have 5 very intelligent justices of the Supreme Court, and they had one little paragraph that dealt with religious freedom. You're right, and they talked about, oh, you can advocate and you can do this, but they left out the word exercise. And that is a word that is directly used in the First Amendment. You have a right to exercise your religion. So when you say that we're
not serving a wedding cake at a gay wedding,
whatever it means, to exercise
that's the
your
example
religion.
that's been used a lot lately.
And they keep, you know,
Bakery.
exactly, you know, and we can go into that. But what my point is that there is a way to change the Constitution. It's not the Supreme Court's decision to change it. It's not up to them. It's in the legislature, and that process is dirty. It's you know, it's a very strenuous process to do it, but it can be done.
Jerry, I think you're sitting next to Anton Scalia's #1 fan.
Okay, all right.
What are your thoughts?
Well, in the discussion so far, you know, the question is should the Supreme Court be influenced by public opinion? Is that right?
Yes.
And I know when
And political expediency.
and
Yes.
when I saw some photos in news media that as the decision, the most recent decisions were about to come out, that there were folks rallied in front of the Supreme Court supporting one position or another. I thought that was kind of inappropriate, because that is more an expression of what the mood of the country is.
Which is usually temporary.
Which is different, that's kind of the opinion versus what the standards have become. And so I don't particularly think that the justices, I would hope that they wouldn't be influenced by the temporary mood of the country, but that they would reflect, their decisions would reflect what the standards have become. And standards don't become, social standards or political standards don't become standards overnight. That's a gradual, or it's a more involved process that moves people from thinking one thing versus another. And you look at the Dred Scott decision back in the 1800s, where I think it was ruled that a runaway slave was returned to his quote-unquote owner or master, just like a runaway horse would be. But that was the standard at that time. Now that standard, and there were people probably who had an opinion otherwise, or the suit wouldn't have been brought, but over the years, that particular mood or that particular opinion evolved into a social standard. And if that is the justice's interpretation or their feeling of what the standard is, then I think that it's almost impossible for them not to act upon that when they're looking at the at the Constitution. And of course, then those rulings change. As you said, you know, they separate but equal, they use the same, because standards had changed, and they will change. And you look at, in the book Team of Rivals about Abraham Lincoln, very extensive in about how that mood and that opinion changed to a standard of thought.
The anti-slavery.
Yes, right. The anti-slavery changed from a mood, it changed from just a mere opinion to an actual standard. And so, yeah, I don't think we should be jumping to a popularity poll and base our decisions on that, but it's more of a, it's bigger than that. You know, the purpose of the Constitution, a lot of it in the Bill of Rights is not to, the rights that it gives us is the right from interference in our lives by the government.
Yes.
That's the purpose of it, and so I think if we get down to that too, we could see.
And public opinion has eroded that.
That's right. Yeah.
Well, you know, I think in the case of the Oberfeld case, though, one of the jobs of the Supreme Court is to interpret whether laws are constitutional. And basically, what they said was the law, like it in Ohio, was unconstitutional. You know, unfortunately, I think though, we all look at the Supreme Court and we judge our opinion by them, unfortunately, based upon our biases.
Yes.
You know, when the Citizens United case was decided, Republicans were extremely happy with the court. When Bush v. Gore was decided, they were very happy with the court. The recent rulings, most of them were more liberal stands. And so Republicans are opposed to them, and now all of a sudden the liberals think the Supreme Court is the greatest thing since sliced bread. You know, and it goes both ways.
And that you're right.
Yeah,
and that's what you have to be really careful
Careful.
of.
Well, that's because Roberts has ruled twice in favor of the Affordable Care Act, because
Right.
he
Yes.
will not let it fail.
Right.
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 And well, and then you also had cases, you know, that were decided all at the same. You know,
Yeah.
Michigan versus the EPA
Right.
was really a good for
Right.
conservatives because it ruled that you know, they could consider or should consider cost in the
Right.
rulings by the EPA.
But one of the big differences that I see is that there's precedent, and there are things there that they can point to. And when we start dealing with sort of the social dynamics of the country at the time, and you can start looking at things, you know, you go back to the Affordable Care Act, you know, you had lawyers putting together those laws. And when the court goes in and says, it says this, how do we interpret this to be this? And when a majority of them can say, well, they actually meant this. Well, where do you stop that?
They should decide what law is not what it should be.
Right.
Right? Okay.
If it's flawed, it's flawed. Fix it. Don't let the court sit there and say, well, we're going to fix it for you.
Well,
that's not their job.
That's Scalia's main argument
Right.
On practically everything. One of the things that I think we have to consider is that at the time of the founding of the country and the Constitutional Convention was going on in Philadelphia, it wasn't clear that we wanted to have a freestanding judiciary. That the states at the time and European democracies at the time had a judiciary that was actually a branch of the legislature. And that Alexander Hamilton had some concerns about whether or not the judiciary should be freestanding. In fact, he was one of the three authors of Publius, the Federalist Papers. And in Federalist 81, he addressed this issue. And he said the arguments, and I'm reading, I didn't memorize this. The arguments, or rather suggestions upon which this charge is founded, are to this effect: the authority of the proposed Supreme Court of the United States, which is to be a separate or independent body, will be superior to that of the legislature. The power of construing the laws according to the spirit of the Constitution will enable that court to mold into whatever shape it may think proper, especially since its decisions will not in any manner be subject to the revision or correction of the legislative body. This is an unprecedented and very dangerous precedent. In the first place, now get this, in the first place, there is not a syllable in the plan under consideration which directly empowers the national courts to construe the laws according to the spirit of the Constitution, or which gives them any greater latitude in this respect than may be claimed by the courts of every state. I admit, however, that the Constitution ought to be the standard for the construction of the laws, and that wherever there is an evident opposition, the laws ought to give place to the Constitution. So it was surprising for me to find out that initially there was discussion even about whether or not to have a third independent branch of government, the judiciary, or it should be part of the legislature. And there was fear that the Supreme Court would be free to make laws however they pleased. Isn't that what's happened? The laws are we've had a lot of laws being made, like Roe v. Wade was a law. It's codified. It was passed by the Constitution.
You look at what recently gets in the paper, gerrymandering.
Yeah.
And if Dr. Ron was here, I'm sure he'd bring it up, gerrymandering. Well, the fact of the matter is, in most states, the law that the legislature has agreed upon is the majority of the legislature at that time, depending upon where it falls, determines the redistricting.
Because whoever's in power
at the time. And if you want it, you can't, I think...
Arizona just changed that.
Yeah, but that's going to court. That's going to court.
It was just decided by the Supreme Court.
Did they?
Yeah, the Supreme Court ruled that they could pass that ability to do the redistricting to an independent commission. So that was determined constitutional.
But there are some states that it's not going to get that far. And the fact of the matter is, if you're going to change it, okay, we change it. But what Patty brought up and what you brought up is, what's good for the goose is good for the gander, in my own words. And we never heard about gerrymandering when the Democrats in the state of Ohio were in power. There was redistricting. I point to keeping Dennis Kucinich in his seat for many years when he should have been sent out to pasture, way before that. But once again, there's a process, and we cannot let the Supreme Court short-circuit that process because it only adds to considerable consternation and additional issues. I mean, all we have to do is look what's happening now with some of the states.
Jefferson had concerns about the Supreme Court as well, which is interesting. So.
Yeah. I don't know what other Publius. There were three authors of the
Madison
and John Jay.
Yeah.
Yeah. and that I don't know that they have ever chimed in on the subject or not. But it's kind of interesting that at least at the time, all of the states had a Supreme Court which was a branch of their legislature, you know, and that apparently European democracies did the same. And I think that he had a lot to worry about there. That and it's interesting, and I don't think you will find in the Constitution the Supreme Court being charged with the responsibility of interpreting according to the Constitution. I don't think it's there.
No.
You don't think it is either? Huh?
No. Yeah.
The
That's what it's evolved into.
But
sadly.
If the courts were a branch of the legislature, wouldn't they be more influenced by political opinion and public opinion than that separate branch is?
Isn't that the reason why we don't have the Ohio Supreme Court chiming in on any challenge to redistricting? They just don't do it because they're subjected to whoever's in power at the time.
That's true.
Well, they're elected as well.
They are elected. It's supposedly nonpartisan, but we all know what parties each.
Sure.
That's our
Judges,
fault as Americans. How many people even know anything at all about a judge when you go to
That's
the
very
vote?
true. Very true.
And that I think that as citizens, we have an awful lot to be embarrassed about when it comes to the way we vote and all. Quite frankly, right now, I get a little tired of hearing it's time for a woman, or it's time for a black, or it's time for a Jew. Those things are not part of the process of selecting a leader.
I don't think you have a Protestant on the Supreme Court right now, do you?
I don't think so.
Yeah, that's it, which
Really?
is interesting.
Well, they're not all Catholics either.
No,
Ginsburg is not.
no.
Well, thank you very much. It was another stimulating. I'd like to visit this subject again. But before we close, I'd like to ask everybody to remember Ron Chamberlin and his family in our thoughts and prayers. Ron's a regular panelist on this panel and is currently at the bedside of his wife Lois, who's in the Cleveland Clinic recovering from a stroke. She has a difficult road ahead, and we all pray for her complete recovery. Thank you.